Good morning. Actually, what is the history of writ? Writ means a command of the sovereignty. Sovereignty may be the king, may be the constitution. When constitution comes into picture, the courts, uh, dictator, so, sultanate, kings, etc., etc. See, initially, when uh, British became more powerful, initially the king, wherever king stationed, his position of the place will be court. That court will normally initially used to issue few writs. Number one, recipe quad redat. That means if anybody occupies the territory of British Empire or England, the king sent their troops, kill them, and regain the position. That is called recipe quad redat, writ. Then writ of pony. Writ of pony means if anybody fail to pay taxes, and that person may report before the king that somebody else has to pay some amount, garnish, and he is not paying and he is not in a position to pay the tax. Then the writ of pony will be issued, and the kingmen will go there, put him in prison, or seize the property and recover the tax. That is writ of. Then writ of litiat. That means nowadays we can file attachment before judgment, Order 38. This writ, you can simply file a case stating that so and so has to pay me the amount, but is likely to leave the country and may escape from the jurisdiction of the king. Then they will issue writ of litiat, arrest him and detain him. This is the way up. After we find before Constitution, the 488 CRPC 1898 contains certain provisions for issuance of writ of habeas corpus. How to issue writ of habeas corpus? There are certain mandatory provisions for which this writ of habeas corpus be issued. Here now the Constitution, Article 32, 227, 226 speaks about the writ of habeas corpus, writ of mandamus, writ of certiorari, writ of prohibition, writ of declaration. These things are there. So you must know what all are the what means the title of every writ. Habeas corpus, you produce him either body or in person. If anybody is confined, not missing, if you file habeas corpus simply stating that my so and so is missing, that may not be come under habeas. You have to include certain allegations showing some respondent possibility, at least possibility of confining or detaining him and preventing him from moving and exercising right to freedom. Then writ of mandamus. Writ of mandamus means commanding to do or not to do. If statutory provisions are there, that authority must do that, but he is not doing that, then writ of mandamus will be issued. If suppose all your papers are good to claim succession certificate or legal certificate, or a pata, if the authority is not issuing, then you can seek for writ of mandamus. Then again there is another writ. Not to do means writ of that if anybody must do certain things, that remove the garbages dumped in front of your house or the pathway, and you want to remove it and the authorities are not doing to remove it, then you can say mandamus, directing them to do. That is writ of mandamus. Then what is about certiorari? Certiorari, call for the records, check the correctness. That is called writ of certiorari. And this is what civil revision as well as criminal revision also contains. But there is a difference between writ of certiorari or revisional power of the civil and criminal court. In civil and criminal court, they will go to some more facts and mistake of fact and other things, so many things. But so far writ of certiorari is concerned, the court only look into the correctness of procedures, competency of the authority who passes the order. If suppose somebody passes the order of punishment, removal, reduction of rank, then you can file writ of certiorari. Then again, question arises, certiorari mandamus. What is that certiorari mandamus? Certiorari means check the correctness of the order passed by the authority. Then certiorari means, suppose if you are applied for issuance of patta, the authority, Tahsildar or RDO passes an order rejecting your claim. If you file a certiorari, that order will be quashed because of your strength of grounds, but you will get no relief. For that, you have to say, call for the request, quash the same, and direct the respondent to issue patta by mutating the record. That is called certiorari mandamus. Then question of prohibition. The prohibition means directing the authority not to do at all certain things which is hazardous, against the public interest, against the statutory. The declaration means, normally declaration comes into place when statutory act or rules are challenged. Writ of declaration to declare that the said act or rules or certain provisions of the acts are null and void, unconstitutional. Here one case, AR 2022, NOC 405 Gujarat, AR online 2021 Gujarat 2685. Then this case is Prashant Sashi Russia Ruya State Bank Government. Therein they say writ of certiorari and prohibition. Difference between writ of certiorari is remedial, whereas writ of prohibition is preventive. They have discussed about that. Go through. Then I left out another writ, that is called Warranto. Warranto is nothing but a writ of information. Right to information is a fundamental right guaranteed in so many constitutional of Western countries and probably Australia and other countries. But in India, Right to Information Act is there, but right to information is time to time being discussed by the Supreme Court. Therefore, the writ of quo warranto means if somebody is occupying a post and according to you he did not possess certain qualification, or subsequent disqualification may not be may be available, so that he may not continue the post, as his very appointment itself is illegal, contrary to the rules. Then writ of quo warranto is issued. And suppose some disciplinary action is committed by the authority, though he is qualified, then that may not be come under writ of quo warranto. That is the area to be discussed deeply. So today we have discussed about all these things. What is writ of habeas corpus? Writ of habeas corpus are two in kind. One being detained under Detention Act, Copy POSA, PIT NDPS, Act 14, so many acts, detention. Therein the authority may detain you without trial for a year or 2 years. The another it is that illegal detention, detaining a major from major without allowing them to go out, or detained by the police official without showing arrest, etc. Then that comes under detention. Two detention is habeas corpus. Writ of mandamus I have already discussed. So you must be very careful and must know about this of all kinds of writs and how the writs are being issued. You may kindly go through the judgment if you are pursuing constitutional law as a postgraduate subject, or you are undergraduate. You can very well answer this question. What is difference between cessionary and prohibition, as discussed by the division bench of Gujarat High Court. Best wishes.